really to everyone, including Mr. McIver, the tragedy that underlies all this. We've all lost Ms. McIver, and whatever happens today doesn't undo that. And I know for many people this has been an extremely difficult process to go through because it required everyone to revisit a very, very dark time. And I'm sorry for those of you who really would have rather been stuck in something else, but here we were. Before me is not the question of precisely what happened when Ms. McIver was shot and the why and wherefore, and that hasn't informed any of the judgment that I've made about what to do going forward with Mr. McIver and his bond. But I think it deserves recognizing the sadness that infuses all of this. I want to thank the attorneys for their hard work. Without much notice, you all sprang into action. Most of you come back to court on time each time too, and I appreciate that. But it is through the good efforts on both sides that it has crystallized to me what exactly was going on. And what I find is that there was a gun found in Mr. McIver's sock drawer. It was a gun that belonged to, at one point at least, Mr. McIver's brother. At some point in early 2016, the McIvers somehow were handling the paperwork for that gun because the paperwork, the ownership documents, the official Glock paperwork wound up in the box that contained what we call the green Glock or the olive Glock that went to Mr. Corey. And we know from Defense Exhibit 1 that that green Glock was included on the insurance inventory that the McIvers put together for firearms that they owned, which means I guess technically they gave Mr. Corey they re-gifted to him. But at some point, not only did the McIvers have Mr. McIver's brother Spike's gun, they even had the paperwork for it because that paperwork ended up in the gun case that had the olive gun that Mr. Corey testified unequivocally, look, they gave it to me, it was an interesting gift, I put it on a chair and I really never touched it until the district attorney's office asked me for it. Given where it was found, its provenance, I find very readily that Mr. McIver possessed the gun. It's unfortunate that Mr. Corey and Mr. Hugh had to be dragged through yesterday what they were dragged through. I find no evidence that Mr. Corey or Mr. Hugh had anything to do with Spike McIver's gun being in Tex McIver's sock drawer, in Tex McIver's closet, in Tex McIver's condominium. And given my observation and the plain facts that the McIvers had the green gun and somehow got the paperwork for the black gun into the green gun box, I don't think that the defense was left to guess as to whose gun it might be and left to flail around to grab onto Mr. Corey inappropriately or Mr. Hugh inappropriately. And I too saw the hurt in Mr. Hugh's eyes. I suspect he won't be buying many more groceries for Mr. McIver. I think it's necessary that I observe that it is unfathomable to me that Mr. Maples advised Ms. Johnson or Ms. Calhoun to move the gun, that was in any way a good idea. I don't attribute that to Mr. McIver. I attribute it to Team McIver. But I ran out of fingers thinking of the ways that that was a bad idea, from losing fingerprint value, just the appearance of obstructing justice and interfering with an ongoing investigation. And it eludes me why no one called police or law enforcement in order to deal with it. But again, I need to make clear that my thoughts about how to work through Mr. McIver's situation are not influenced by that. Mr. Maples, you need to know, if I'm ever asked by folks reviewing your conduct, I can't endorse that suggestion. I am also concerned about Ms. Johnson's lack of candor under oath. That is probably a matter for another day, but that was another troubling aspect of the proceeding that we went through over the last few days. So, in sum, I find that Mr. McIver has violated a central provision of his bond. He possessed a firearm. And I need to work through what to do about that. I appreciate Mr. Hill's observation, if not quite a concession, that it's hard to get around the fact that it was a McIver gun in a McIver sock drawer in the McIver condominium. It could have been a lot worse. Mr. McIver wasn't caught carrying it, wasn't found on his person, no question about that. Blessedly wasn't involved in that gun being discharged. It's alarming that there was ammunition capable of being fired by that gun in the adjacent drawer. And it's alarming. I'm not going to engage in any stretch work to say, is ammunition prohibited by the bond? I don't need to go there, because the gun was prohibited. And there it was in the sock drawer in the closet in the condominium. So, given the size of the box and the frequency of access to the sock drawer, I find that Mr. McIver must have known that that gun was there, that this isn't just an accident and a shocker for everyone. And given how much tragedy has befallen Mr. McIver and his family and Ms. McIver's family and friends, it is remarkable and alarming that there was still a gun that accessible to Mr. McIver. It wasn't found in an attic inside a dusty box that hadn't been touched in months and months, but it was in a spot that was accessible and had been accessed, and that was plainly prohibited for good reason. I am going to revoke Mr. McIver's bond, but I am amenable to reinstating it. And so what that means is that Mr. McIver is going to go into custody today, but I'm going to share with both sides conditions of a bond that I believe would address the concerns I have flowing from the discovery of the McIver gun in the McIver sock drawer in the McIver condominium. And Mr. Hill, I'm going to take you up on your invitation to share with me, and I'll let the state have input as well, of course, as to how we structure this bond. But until its structure is in place, Mr. McIver needs to be in a place where I can be most assured that there won't be guns around, and that will be in custody. The bond I envision will have Mr. McIver on house arrest in Atlanta at the Kingsborough address, not in Putnam County. He will need to wear an ankle monitor that would send a direct alert to, we can sort out whether it's law enforcement or the district attorney's office, but that someone on the other side of the V in State versus McIver, on the state side of the V, would know immediately if there was a violation of the house arrest. There will be no visitors under 18 allowed in the Kingsborough apartment. The apartment will be subject to random searches, not to be oppressive, not daily, not hourly, but random searches. The defense team will need to work through the logistics. It may become necessary that Mr. McIver drop his executorship. I'm not requiring that, but I am including as a condition of the bond that I envision I would be willing to sign that Mr. McIver have no contact with Ms. Johnson. So I'm not offering an opinion on the executorship. I appreciated Mr. Watkins's input when we were trying to maintain a status quo from the start of our hearing to the end, that it's necessary for the executor to talk to the estate manager. That's not possible under the bond I'd be willing to sign. I have a pretty limited view as to what would be a reason for Mr. McIver to leave the apartment. Certainly his attorneys can visit him there, but where I open it up to submission from both sides would be reasons for Mr. McIver, other than coming to court, to leave his condominium. Should appropriate conditions be fashioned and I sign the bond, that bond will be good for 60 days. And by that I mean, if Mr. McIver remains unindicted, then I invite everyone to return to revisit these conditions, because I don't intend for such restrictive conditions to be in place in perpetuity. So that is a clock that the state is going to want to focus on, and that clock would begin from the entry of the bond that I would sign that satisfies these conditions. My concern is for everyone's well-being. Mr. McIver and firearms don't mix well anymore. I trust that for dozens and dozens of years, Mr. McIver derived great pleasure from being around guns and firing them and hunting and collecting them. But as of about 7 months ago, that equation reversed itself entirely. And it just can't happen again. I don't view, as I've said, Mr. McIver as any flight risk. The point of the house arrest is I think there can be conditions that will keep everyone at minimal risk of there being another gun incident, accidental or intentional. Jail would accomplish that, but my charge is to find the least restrictive conditions. And Mr. McIver is in a position to enable ankle monitor, monitoring system, etc., that would address that issue. If people feel safe coming to visit him and they're over 18, they can come and visit him, but he isn't going to be able to go visit other people. So that's where I come down. I will be able to respond to written submissions very quickly. I have no more large windows of time that aren't already spoken for. I start a murder trial on Monday, and I had to push everything else I had this week other than drug court to tomorrow and Friday. So I don't mean to deny anyone due process. I feel like much process was had by both sides in this matter in the many hours we've been together. I don't want to delay any more than necessary consideration of a bond proposal consistent with what I've described. But submitting something in writing will get quicker turnaround than demanding a hearing. If you demand a hearing, I'll give you one because of what's at stake. But we might not talk until next Friday. So, and it would be the defense demanding it. The state won't hold it hostage by demanding a hearing. I'm not suggesting you would, Mr. Rucker, but I certainly want to give Mr. McIver and his team an opportunity to be heard in whatever way they want as to what conditions will make sense. And by sharing this with you, I'm trying to give you a framework that I'm amenable to in light of the concerns that I developed over the several days of hearing testimony about what did and didn't happen and who spoke with whom, etc. So I want to make sure, Mr. Hill, you have as complete an understanding as possible of what I'm trying to do here. Do you have any questions about what I've said?
No, Your Honor, I try to take copious notes. I think I understand.
Okay, I saw you taking notes. That doesn't mean I spoke clearly. It means you take good notes.
No, you did, and I intend to try and put together a document for you and get it to you first thing tomorrow.
Okay.
I'll share a copy with the district attorney's office.
Okay. In doing so, it would be helpful if you included a specific vendor that would provide that monitoring, because the concept is what I'm comfortable with. Both sides need to be comfortable with the vendor. It needs to be an independent vendor that has no connections, business, personal, or otherwise, with anyone Mr. McIver is associated with. And I appreciate he is a well-known person, so there needs to be separation there.
Yes, sir. And if Mr. Rucker has anyone that the DA's office routinely works with, I'd invite that information.
Sure. And you should share that, Mr. Rucker. Do you have any questions about what I've described?
No, sir.
Okay. Mr. McIver, a very difficult situation has gotten more complicated, and I'm sorry for that. I am doing what I believe is justified by what I heard. I don't know you well, and I am not attributing to you anything other than the kinds of things we talked about today. And I just want to ensure that you are in a place that keeps you safe, everyone else safe, and allows this process to move forward. If the state has, meaning the district attorney's office, has not moved forward with charges within those 2 months, then we will talk again about adjusting things back to how they were. Because I am viewing this as, it's not jail, to be clear, but Mr. McIver is effectively on house arrest, and that is an extremely restrictive situation, given that the default presumption is someone innocent until proven guilty ought to be free on bail. But we had a very serious situation develop in light of what brings us all together to begin with. And I think this is the appropriate way to work through it. Mr. Rucker, anything else for the state?
Your Honor, no, there's nothing else on behalf of the state.
Okay. Mr. Hill, anything else on behalf of the defense?
No, Your Honor, we appreciate the court's time and patience.
Okay, on a related matter, my conference room is full of boxes that were seized pursuant to search warrants, plural. And I understand there's been some segregation. Some boxes have been designated okay for DA to take. Judge Goger is now handling any civil matters related to that. Should I be reaching out to him to relocate those boxes? I don't know where things have been left, and I am blessedly not in the middle of it anymore.
I am confident that Judge Gover would love to hear from you about transferring boxes to him.
Okay, but
I suspect that's what you need.
Okay, all right.
And Your Honor, if we have not picked up the boxes that have been agreed to previously, we will make sure we take care of that first thing tomorrow morning.
Okay, you'll need to swing by my chambers because we've got the key to the room.
Yes, sir.
All right, thank you.
Thank you.
Thank you, Your Honor. Thank you. A couple of minutes. I know I'm not going to be able to take on. The only thing I want to probably do is read
Yes. Yep. Thank you for reminding me. I've got something on file. I do. Thank you. So I'll draft that up. I'm gonna go do it. Sort of